Title, year, number, type, all UK legislation, excluding originating from the 1st of February 1991, the 2nd of February 1991, the 21st of May 1991, the 8th of April 2010, the 26th of March 2015. Changes to legislation. C1. I1. I recital of Stat. 1 W and M Sess. 2. C. 2. Section 2. And that the late Queen and Duke of Gloucester are dead, and that His Majesty had recommended from the throne a further provision for the succession of the crown in the Protestant line. The Princess Sophia, Electress and Duchess Dowager of Hanover, daughter of the late Queen of Bohemia, daughter of King James I, to inherit after the King and the Princess Anne, in default of issue of the said Princess and His Majesty, respectively, and the heirs of her body, being Protestants. Whereson the first year of the reign of your Majesty and of our late most gracious Sovereign Lady Queen Mary, of blessed memory, an Act of Parliament was made intituled, an Act for declaring the rights and liberties of the subject and for settling the succession of the Crown, wherein it was, amongst other things, enacted, established and declared that the Crown and Regal government of the kingdoms of England, France and Ireland and the dominions thereunto belonging should be and continue to your Majesty and the said late Queen during the joint lives of your Majesty and the said Queen and to the survivor, and that after the decease of your Majesty and of the said Queen the said Crown and Regal government should be and remain to the heirs of the body of the said late Queen, and for default of such issue to Her Royal Highness the Princess Anne of Denmark and the heirs of her body, and for default of such issue to the heirs of the body of your Majesty, and it was thereby further enacted that all and every person and persons that then were or afterwards should be reconciled to or shall hold communion with the See or Church of Rome or should profess the Popish religion, should be excluded and are by that act made forever incapable to inherit, possess or enjoy the crown and government of this realm and island and the dominions thereunto belonging or any part of the same, or to have use or exercise any regal power, authority or jurisdiction within the same, and in all and every such case and cases the people of these realms shall be and are thereby absolved of their allegiance, and that the said crown and government shall from time to time descend to and be enjoyed by such person or persons being Protestants as should have inherited and enjoyed the same, in case the said person or persons so reconciled, holding communion, professing, as aforesaid, were naturally dead, after the making of which statute and the settlement therein contained your Majesty's good subjects, who were restored to the full and free possession and enjoyment of the religion, rights and liberties by the providence of God, giving success to your Majesty's just undertakings. Cumraig. Advanced Search. Act of Settlement, 1700. Acts of the English Parliament 1700 c. 2 Regnal. 12 and _13 will 3, whole Act. Changes over time for Act of Settlement 1700. There are currently no known outstanding effects for the Act of Settlement 1700. Act of Settlement 1700. 1700 Chapter 2 12 and 13 will 3. An act for the further limitation of the Crown and better securing the rights and liberties of the subject. Modifications etc. Not altering text. Short title given by Short Titles Act 1896, c. 14, School. 1. Commencement information. Act in force at royal assent. Legislation.gov.uk. Home browse legislation, new legislation, coronavirus legislation, changes to legislation, search legislation. Search. Table of contents, content, more resources. Previous, next, plain view, print options. F1. X1. F1. X2. X1, X2, X3. F1. C2. 2. The persons inheritable by this act, holding communion with the Church of Rome, incapacitated as by the former act, to take the oath at their coronation, according to Stat. 1 W and MC. 6. F2. C3. 3. Further provisions for securing the religion, laws, and liberties of these realms. And unwearied endeavors for that purpose had no greater temporal felicity to hope or wish for than to see a royal progeny descending from your Majesty, to whom, under God, they owe their tranquility, and whose ancestors have for many years been principal assertors of the reformed religion and the liberties of Europe, and from our said most gracious sovereign lady, whose memory will always be precious to the subjects of these realms, and it having since pleased Almighty God to take away our said sovereign lady and also the most hopeful Prince William Duke of Gloucester, the only surviving issue of Her Royal Highness the Princess Anne of Denmark, to the unspeakable grief and sorrow of your Majesty and your said good subjects, who under such losses being sensibly put in mind that it standeth wholly in the pleasure of Almighty God to prolong the lives of your Majesty and of Her Royal Highness, and to grant to your Majesty or to Her Royal Highness such issue as may be inheritable to the Crown and Regal Government aforesaid by the respective limitations in the said recited Act contained, do constantly implore the divine mercy for those blessings, and your Majesty's said subjects having daily experience of your royal care and concern for the present and future welfare of these kingdoms, and particularly recommending from your throne a further provision to be made for the succession of the Crown in the Protestant line for the happiness of the nation and the security of our religion, and it being absolutely necessary for the safety, peace, and quiet of this realm, to obviate all doubts and contentions in the same by reason of any pretended titles to the Crown, and to maintain a certainty in the succession thereof, to which your subjects may safely have recourse for their protection in case the limitations in the said recited Act should determine therefore for a further provision of the succession of the Crown in the Protestant line, we your Majesty's most dutiful and loyal subjects, the Lords Spiritual and Temporal and Commons, in this present Parliament assembled, do beseech your Majesty that it may be enacted and declared, and be it enacted and declared by the King's most excellent Majesty by and with the advice and consent of the Lords Spiritual and Temporal and Commons in this present Parliament assembled, and by the authority of the same, that the most excellent Princess Sophia Electress and Duchess Dowager of Hanover, daughter of the most excellent Princess Elizabeth, late Queen of Bohemia, daughter of our late Sovereign Lord King James I of happy memory, be and is hereby declared to be the next in succession in the Protestant line to the imperial crown and dignity of that said realms of England, France, and Ireland, with the dominions and territories thereunto belonging, after His Majesty and the Princess Anne of Denmark, and in default of issue of the said Princess Anne and of His Majesty respectively, and that from and after the deceases of His said Majesty are now Sovereign Lord and of Her Royal Highness the Princess Anne of Denmark, and for default of issue of the said Princess Anne and of His Majesty respectively, the Crown and Regal Government of the said kingdoms of England, France, and Ireland, and of the dominions thereunto belonging, with the royal state and dignity of the said realms, and all honours, styles, titles, regalities, prerogatives, powers, jurisdictions, and authorities to the same belonging and appertaining, shall be, remain, and continue to the said most excellent Princess Sophia and the heirs of her body, being Protestants, and thereunto the said Lords Spiritual and Temporal and Commons shall and will, in the name of all the people of this realm, most humbly and faithfully submit themselves, their heirs and posterities, and do faithfully promise that, after the deceases of His Majesty and Her Royal Highness and the failure of the heirs of their respective bodies to stand, to maintain and defend the said Princess Sophia and the heirs of her body, being Protestants, according to the limitation and succession of the Crown in this Act specified and contained, to the utmost of their powers, with their lives and estates, against all persons whatsoever that shall attempt anything to the contrary. Provided always, and it is hereby enacted, that all and every person and persons who shall or may take or inherit the said crown by virtue of the limitation of this present Act, and is or shall be reconciled to or shall hold communion with the See or Church of Rome, or shall profess the Popish religion, shall be subject to such incapacities as in such case or cases are by the said recited Act provided, enacted, and established, and that every king and queen of this realm who shall come to and succeed in the imperial crown of this kingdom by virtue of this Act shall have the coronation oath administered to him, her, or them at their respective coronations, according to the Act of Parliament made in the first year of the reign of His Majesty and the said late Queen Mary Interchuld, an Act for establishing the coronation oath, and shall make, subscribe, and repeat the declaration in the Act first above recited, mentioned or referred to, in the manner and form thereby prescribed. And whereas it is requisite and necessary that some further provision be made for securing our religion, laws, and liberties from and after the death of His Majesty and the Princess Anne of Denmark, and in default of issue of the body of the said Princess and of His Majesty respectively, be it enacted by the King's most excellent Majesty by and with the advice and consent of the Lords Spiritual and Temporal and Commons in Parliament assembled, and by the authority of the same, That whosoever shall hereafter come to the possession of this crown shall join in communion with the Church of England as by law established, that in case the crown and imperial dignity of this realm shall hereafter come to any person not being a native of this kingdom of England, this nation be not obliged to engage in any war for the defense of any dominions or territories which do not belong to the crown of England without the consent of Parliament. That after the said limitation shall take effect as aforesaid, no person born out of the kingdoms of England, Scotland, or Ireland, or the dominions thereunto belonging, although he be made a denizen, except such as are born of English parents, shall be capable to be of the Privy Council or a member of either House of Parliament, or to enjoy any office or place of trust either civil or military, or to have any grant of lands, tenements, or hereditaments from the Crown to himself or to any other or others in trust for him. That no pardon under the Great Seal of England be pleadable to an impeachment by the Commons in Parliament. Editorial information. Variant reading of the text noted in the Statutes of the Realm as follows. Uncapable 00 refers to a collection in the library of Trinity College, Cambridge, interlined on the roll. Interlined on the roll. Textual amendments. Words in preamble omitted, the 26th of March 2015, by virtue of succession to the Crown Act 2013, c. 20 s. 5-2, school. Para. 3 with school. Para. 5 SI 2015 894, Art. 2. Modifications etc. Not altering text. S. 1 amended by His Majesty's Declaration of Abdication Act 1936, 1 EDW. 8 and 1 Geo. 6 C. 3 S. 1 2. Textual amendments. Words in S. 2 omitted, the 26th of March 2015, by virtue of succession to the Crown Act 2013, c. 20 s. 5-2, school. Para. 3 b, with school. Para. 5 SI 2015 894, Art. 2. Modifications etc. Not altering text. S. 2 amended by Accession Declaration Act 1910, c. 29 s. 1. X2. X2 X2. X3. 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 F2. F3. F4. F5 X4. F6. X4. F3 F4 F5 F6. C4. C5. C6 C7 C8. C9. C10. IV. The laws and statutes of the realm confirmed. And whereas the laws of England are the birthright of the people thereof, and all the kings and queens who shall ascend the throne of this realm ought to administer the government of the same according to the said laws, and all their officers and ministers ought to serve them respectively according to the same, the said lords spiritual and temporal and commons do therefore further humbly pray that all the laws and statutes of this realm for securing the established religion and the rights and liberties of the people thereof, and all other laws and statutes of the same now in force, may be ratified and confirmed, and the same are by His Majesty by and with the advice and consent of the said Lords spiritual and temporal and commons, and by authority of the same ratified and confirmed accordingly. Back to top. Editorial information. Interlined on the roll. Textual amendments. Words repealed by the Act 4 and 5 Ann. C. 20, S. 27 and the Act 1 Geo. 1 Street 2 C. 51. Words repealed, so far as they relate to British subjects and citizens of Air, by British Nationality Act 1948, c. 56, School. 4 pt. I. Words repealed by British Nationality and Status of Aliens Act 1914, c. 17, School. 3. Words repealed by the Act 4 and 5 Ann. c. 20, s. 28, EW. By Statute Law Revision and Civil Procedure Act 1881, c. 59, School. And N.I. By Statute Law Revision Act 1950, c. 6, School. 1. Modifications etc. Not altering text. S. 3 excluded by Army Act 1955, c. 18, s. 21, 4 Air Force Act 1955, c. 19, s. 21, 4 Aliens Employment Act 1955, 4 and 5 Elise. 2c. 18, s. 11, Army and Air Force Act 1961, c. 52 s. 36 1 Armed Forces Act 1966, c. 45 s. 16 1 and Solicitors Act 1974, c. 47 s. 29, applied by Regency Act 1937, c. 16 s. 3 2 s. 3 modified by British Nationality Act 1981, c. 61, CF 87, School. 7 as explained, 8 April 2010, by 2010 c. 25, s. 47 S3 excluded by SI 1991-1221, Art. 3. S. 3 excluded, 28 May 1998, by 1998 c. 12, s. 4 4, SI 1998-1313, Art. 2. S. 3 excluded, 1 December 1998, by 1998 c. 38, s. 13 2, with SS. 139, to 143, to SI 1998 2789, Art. 2. S. 3 restricted, 1 July 1999, by 1998 c. 46, s. 16 2, SI 1998 3178, Art. 2. S. 3 excluded, 2 December 1999, by 1998 c. 47, s. 36 7, with S. 95 SI 1999 3209, Art. 2, School. S. 3 excluded, 1 September 2004, by Courts Act 2003, c. 39 SS. 6, 110, School. 2 Para. 14, SI. 2004-2066, Art. 2 S3 excluded, 20 November 2003, by Courts Act 2003, c. 39 S. 42. S. 3 modified, 1 January 2007 for EWS, 1 July 2008 for NI. By Electoral Administration Act 2006, c. 22 SS. 18 1, 377, SI. 2006 3412, Art. 3, School. 1 Para. 14 E, with School. 2 SI 2008 1316, Arts. 2 2 4 B. S. 3 restricted, 28 March 2009 for certain purposes, otherwise 31 October 2009, by Armed Forces Act 2006 c. 52 SS. 340, 4, 383. SI 2009 812, Art. 3, with transitional provisions in SI 2009 1059, SI 2009 1167, Art. 4. S. 3 Amendment to earlier affecting provision 1981 c. 61, School. 7 8 April 2010, by Constitutional Reform and Governance Act 2010, c. 25 SS. 47 252. Help about us sitemap accessibility contact us privacy notice cookies. All content is available under the Open Government License v3.0 except where otherwise stated. This site additionally contains content derived from EUR Lex, reused under the terms of the Commission Decision 2011-833, EU on the reuse of documents from the EU institutions. For more information see the EUR Lex Public Statement on Reuse. Copyright Crown and Database Right. Previous Next.